In 2018, a group of blue-collar dads with no muscle, juice, money, or influence were able to convince nearly a quarter of the Illinois state legislature that our family law system was broken. For a brief moment, it seemed reform was a sure thing, until it wasn't. Now, I've sat on this project for about 2 years because although this is about Illinois Fathers for Equality, which I will refer to as Illinois Fathers for brevity purposes, most people really can't tell one 50-50 group from the next. And because this is an emotionally sensitive topic for many, I waited this long so that tempers could sort of cool. And to be clear, Illinois Fathers isn't associated with any major organization like Americans for Equal Shared Parenting or the Fathers' Rights Movement. They are their own thing, or were. So who were the Illinois Fathers? Well, it was the brainchild of Chad Loudermilk and Corey Ray. Sometime in 2017, Chad, he works as a truancy officer at the Regional Office of Education. Well, he wrote what was later known as HB 4113 and its identical twin, HB 185. Both bills create a mandatory allocation of 50-50 parenting time, ostensibly as a starting point for fairness. Somehow, Chad and Corey were able to convince a state representative, LaShawn Ford, to sponsor their bill, and despite not having the resources to give out campaign contributions or having any influence in Springfield, the bill took off like a rocket. I have two competing theories. The first is that the entire House simply fell in love with the bill. The second, well, we have to go back to 2014 for context. Back then, the ISBA was pushing the IMDMA version 2.0 or maybe 3.0, depending on who you ask, on the state legislature. Competing with that bill was HB 5425, which was not a 50-50 bill. It actually started with Dad getting 35% overnights. Now, understand that family law has gotten so complicated in Illinois that the state legislature relies very heavily on what the ISBA presents to them for purposes of future legislation. But not everybody in Springfield is happy about that relationship. It's possible the ISBA treated 5425 support as nothing more than a protest vote. And when HB 4113 came along, I suspect the ISBA figured the bill would muster a few protest sponsors, tops. Then this happened. I don't believe it! And with nearly 20 co-sponsors, the ISBA realized something.
He doesn't know it's a damn show. He thinks it's a damn fight. Finish this bum and let's go home.
And the ISBA was so concerned, they decided to meet with the 50-50ers in hopes that they would just, pack up and go home. But that meeting didn't go so well.
And the only two differences that I see here, right, in the proponents and the opponents is that the opponents to this stand to gain financially, while the proponents of this bill stand to gain by having time with their children.
So how did the ISBA manage to beat back this bill? Well, I think the better question is, how did Illinois Fathers snatch defeat from the jaws of victory? And the answer, I suspect, is the very thing that got them where they were: their own leaders. You see, 50-50ers have, historically speaking, had significant challenges getting people with the right temperament to lead each individual state's reform efforts. Now, here's a recent example. Pictured here is a veteran. He ran for public office, claimed that various false OPs had been lodged against him, that it had been years since he'd seen his kids. He'd often attack just about everybody involved in his case on Facebook almost on a daily basis. And no, I'm not talking about this guy. I'm talking about this guy, Michael McDonald. He's one of the leaders behind Nevada's 50-50 movement. Keyword was. Turns out those false OPs, well, they weren't so false after all. He stalked his ex. He was charged criminally for violating those OPs. And then, in just the weirdest thing possible, he stalked the prosecutor that was charging him. Take a look.
The attorney's office was holding a CLE. At the conclusion of that CLE, when there were about 3 attorneys from the DA's office still remaining there, the defendant showed up at that location, came over to Nels Christensen, the attorney in charge of CLEs, and stated that he wanted to attend all of our CLEs because they were supposed to be open to the public. He became very argumentative and belligerent and demanded to be attending our CLEs. He then grabbed our CLE schedule for the rest of the year and left with it. So we're now having to send investigators to all of our CLEs out of safety concerns.
And every time they locked Michael up, he rarely went quietly.
Violation on either of these. In fact, it's probably the 5th or 6th.
Listen, you guys are really throwing me out. Judge, seriously, you really want to...
I don't really want to put anybody in jail, but when you don't do what you signed up to do and then you violate the court order, it's problematic.
Are you serious?
So based upon that, I am granting the motion. You can have him evaluated by a psychiatrist.
Put your hands behind your back. Put your hands behind your back.
Greg, can you please tell Mike got a mentally valve already done?
Dude.
Don't fight. Stop. Come on.
Mike, calm down.
Hands behind your back.
Mike, calm down. Just relax. Deep breath. Mike, take a deep breath.
I got a mentally valve. I just want to see my kids. Come on. I've done nothing.
Mike,
So just take it
calm
backwards.
down. Dude, take a deep breath.
After Michael's first conviction, virtually every trace of him disappeared from the Fathers' Rights websites. Now, to be fair, Michael had nothing to do with Illinois Fathers, but this man did, and his name is Stephen Westerfield. He was a member of the Illinois Fathers Board of Directors. He was a hardcore 50-50er who ran unsuccessfully for public office. In 2018, his ex got an order of protection on him, and shortly thereafter, he allegedly violated it multiple times and is currently facing multiple criminal charges in Sangamon County. His specific role with Illinois Fathers is a bit opaque, but what is known is what Illinois Fathers did when they set their sights on this man. His name is Michael Strauss. He's a family law attorney and vice president of a battered women's shelter called a Safe Space. By all accounts, he's pretty much a nice guy who's well liked by, well, everybody. So he comes down to testify against 40113. He doesn't mention money in his speech, and after it's all over, Lindsay Parkhurst asks him this question.
The effect of a 50-50 presumption would have on families that require food stamps or public aid assistance?
And Mike answers as follows.
Currently, the state of Illinois gets federal funding and grants, and individuals obviously get state aid premised upon the amount of individuals in the state with a child more than half the time. There's very real potential for this state to lose federal funding, and I'm talking millions, possibly hundreds of millions of dollars, as well as parents not being eligible for the state aid. And this is, food stamps, this is the temporary assistance to needy families, subsidized housing, child care assistance, to name a few. This issue has not been addressed by those in favor of this law, and so potentially Illinois loses a lot of money, poor families lose more money, and our state gets less money.
Now, keep in mind, Michael is addressing cases involving state aid, lower income parents, if you will, and to get state aid, if you're not living in the same household as the other parent, there generally needs to be a support order in place. Doesn't make any sense to have taxpayers subsidize the child because the other parent chooses not to. So HFS steps in, but under a 50-50 mandate, the first thing a reluctant parent is going to do is probably counterclaim for their 50-50, and the law has to give it to them absent agreement or trial. And I hate to break it to 50-50ers, but there are a lot of parents out there who don't take care of the children they bring into the world. Now, they may not be the majority of cases, but unfortunately their numbers are far higher than Mark Ludwig would publicly admit. And those parents just want HFS off their back. They really have no intention of exercising the parenting time. And since HFS can't get involved in parenting matters, mom or sometimes dad are on their own, so child support becomes the exception rather than the rule under 4113. Not because dad has 50-50, but because mom knows he can counterclaim, so she lets sleeping dogs lie. Now, Illinois gets reimbursed for their HFS costs, and if you were to say to me, hey, David, would you be shocked to learn that Illinois sends Uncle Sam an inflated bill for HFS enforcement? I guess my reaction would be this.
I'm shocked to find that gambling is going on in here.
You're winning, sir.
Oh, thank you very much. Everybody out at once.
And I think that's where Michael might have been going. I don't know. But what I do know is that the 50-50ers took his response. They chopped up the video to make it look like that was his main speech in opposition. And then they posted it everywhere. From what I understand, his email inbox, his firm website page, everything was blown up with comments just like this. And it probably brought out the worst within the 50-50 movement. The worst comment I saw is from this gentleman, Vito Glazers. As of today's date, he's still listed as an admin for Illinois Fathers, who leveled this allegation that Michael suborns perjury. Despite presenting no facts to back up any of this, various board members and advocates rushed to endorse this charge. The situation gets even more bizarre from here. At first, the Illinois Fathers, including their leader, flat out deny they had anything to do with the video. And then, about 5 or so days later, they do a 180 and change their mind, taking full credit for the video. And then when they were asked to take it down because people were sending Michael and his family death threats, they refused and stated this: "I will not take the video down, and I'll just warn you now, there will be many more to come exposing the truths of what the opposition said. We didn't produce or upload the original video, but I'll own up to anything I personally make because I don't hide from monsters, I slay them." However, the same cannot be said for the state legislators who withdrew their support once the Facebook comments became public. Another tactical error can be traced back to November of 2017 when 4113 was first introduced. Initially, Representative Lindsay Parkhurst, who I just mentioned a few minutes ago, came out in support of the bill, but changed her mind a couple weeks later. Illinois fathers apparently were very upset by this, and although I couldn't find the initial post asking for people to send her angry emails, I was able to locate this one. And despite Chad's promise that he would, quote, halt the attack, end quote, it doesn't appear that Lindsay Parkhurst ever changed her position on 4113. 4113 expired in the fall of 2018 without a floor vote, so in 2019, House Bill 185, which is identical to 4113, was introduced. But all those co-sponsors that lined up last year, well, after all that happened, Illinois fathers could only muster one beyond the bill's sponsor. Now, you see that it says 4, but I'm going to get into that oddity in just a minute. You see, at the time that HB 185 was called for hearing, they only had 2 co-sponsors, and the reason why Illinois fathers suddenly had virtually nobody backing their bill was made clear within the opening seconds of the hearing.
On the record, over the course of the past year, proponents of the bill, and I'm not saying anyone in this room, have engaged in inappropriate and unprofessional behavior. Several individuals who testified against the bill last year have been bullied, threatened, harassed online via social media, and had false negative reviews posted on Yelp or other business sites. I've heard from several of these individuals, gotten screenshots.
All right, let's play that again.
Heard from several of these individuals, gotten screenshots.
Remember this? Yeah. Things went downhill from here. About an hour later, when it was time for the opposition to speak, the chairlady stops the proceedings to address the cameraman.
Thank you, and I will note there is a gentleman videotaping this, and I trust you will be responsible with the use of that video, and we won't see it in a different form doctored up somewhere later.
And the worst was yet to come. The coup de grace to this hearing occurred near the end, where a question was posed asking how much evidence is required to rebut the presumption that is outlined in HB 185.
Key, knowing what is required to rebut that presumption. Does anyone in the room
Which the bill's sponsor, LaShawn Ford, answered under oath as follows.
I've been advised that any evidence will rebut the presumption.
So any evidence rebuts 50-50. The evidence the court considers as those 17 factors, which the 50-50ers admit are still baked into the statute. And one of the factors is mom's wishes. So if mom testifies at hearing that she doesn't want 50-50 and any evidence rebuts, well, basically the 50-50 presumption ends up being pointless. Illinois fathers spent the last 3 years chasing their tail on a bill that was legally unstable. Despite what happened at the hearing, in late June, Illinois fathers posted an update indicating that it was the best legislative hearing on shared parenting to ever occur in the nation. However, behind closed doors, Illinois fathers quickly amended the 50-50 bill on March 11, 2019, which makes sense given the defect in question, and after the amendment was proposed, 2 more representatives came back on board, Darren Bailey the very next day, and John Cabello about a year later. Except the amendment got rid of any mention of 50-50 parenting time. You know, the only substantive change that I saw was at scrap factor number 3. Illinois fathers didn't disclose this bait and switch to their members until about 2 weeks later, and nowhere in the post does it indicate that 50-50 was eliminated or even why it was amended. However, a few people did do their due diligence, and once word got out, things got really hairy. In May, Illinois fathers had to close their main office. In June, although there are competing narratives as to what happened, it appears Americans for Equal Shared Parenting, which previously had close ties with Chad, well, they suddenly severed them. Chad was disinvited from their national conference, and all mention of him on the Equal Shared Parenting websites, at least from that point forward, ceased. Sadly, the self-inflicted injuries don't stop there for the 50-50ers, because one thing I forgot to add, you may recall Stephen Westerfield from earlier. Well, apparently he met with Jim Covington way back in 2014 or thereabouts to hash out a potential compromise on HB 5425. You may recall it's that 35% parenting time bill I talked about. And for whatever reason, he secretly recorded it. Now, Jim didn't say anything crazy during the conversation, much to Stephen's disappointment, I'm sure, but it didn't stop him from uploading it to YouTube right after the Michael Strauss incident occurred, where you can still watch it as of today. Unfortunately, I can't see Jim trusting a 50-50 ever again after everything that's happened, so I'm afraid that negotiation bridge may be forever toast. And in either event, you know, as you look back, what was once a lifetime chance to effectuate historic reform appears to have been thrown away because the leaders valued getting the last word in versus getting the best outcome for their dads. And that is the story of that.